Hi, I'm Whitney Espich, the CEO of the MIT Alumni Association, and I hope you enjoy this digital production created for alumni and friends like you.
Good afternoon, ladies and gentlemen. It's 1:01 p.m. Time to get started. Hi, I'm Rick Lufkin, chair of MIT's Cardinal and Gray Society. Welcome to our program on digital assets, social and financial. More about that in a few moments. As always, we are pleased to have with us today members of our companion organization, the Emma Rogers Society. Thank you for joining Cardinal and Gray members today and for your continuing support of the Institute. Cardinal and Gray is presenting this program in conjunction with the class of 1967, which originally developed the idea. Let me give you a little background here. The class of 67 has a close-knit group of classmates living in the Boston area. When one of their number, John Ross, passed away, the other members of the group banded together to help his widow, Myrna, manage the administrative aftermath of his passing as it pertained to digital assets. They found the task daunting and vowed to do something to make the process less burdensome for those of us who will face it in the future. Bob Howard and Andy Eggendorf were tasked with the responsibility of framing the issues and identifying potential expert resources for a program on the subject, a responsibility they fulfilled admirably. Thus, we are here today. Thanks, Bob and Andy. We have three well-qualified panelists today who will present different perspectives on the issues. Kristin Dzialo is a partner with the Boston-based law firm of Rubin and Rudman in their trusts and estates practice group. Her focus will be on the legal aspects of digital assets, in particular, how to organize and plan for digital assets to ease the administrative burden on your loved ones in the event of your disability or death. Taj Dryja is a research scientist with the Digital Currency Initiative, which is part of the MIT Media Lab. Digital currency, the generic term for Bitcoin and its kin, may potentially be a significant and somewhat mysterious component of your digital financial legacy. Taj is a creator of the Lightning Network, one of the most promising Bitcoin scaling solutions. He leads DCI research focused on the scaling and interoperability of cryptocurrencies and smart contracts. Betsy Ehrenberg, who comes to us from the world of software entrepreneurship, is CEO and founder of Legacy Concierge, a fintech firm delivering digital asset administration services. She advises clients on a broad range of security protection options for their portfolio of digital and tangible assets. She specializes in securing assets from custodians, especially those custodial companies who are reluctant to release control to the fiduciary. That sounds entertaining. For our program today, we asked each of our panelists to make an ongoing opening presentation followed by an exchange of views. Since we are dealing with legal matters here, it naturally comes with a disclaimer. This event is for general informational purposes only. Specific legal advice for your particular circumstances is neither being offered nor implied. You will have the opportunity to submit questions today. Please type them into the Q&A box. That's the Q&A, not the chat box, on Zoom whenever they occur to you. I will work with the panelists to ensure as many get answered as possible. I am now delighted to pass the virtual microphone to our first speaker, Kristin Dzialo. Kristin?
Thank you so much, Rick, and thank you everyone for joining today. I'm going to share my screen, which hopefully you'll be able to see. And if anyone has any issues, oh, of course, always some issues. So let me try that one more time. Bear with me. Okay. Of course, we did a test run prior to the presentation and everything worked great. This is what happened. So, okay, here we go. That should work. Hopefully everyone can see this. As Rick stated, my name is Kristin Dzialo. I'm a trust and estates attorney And primarily my practice focuses on the estate planning side. So for today's presentation, I will be working through what digital assets are in their general form, certain parts of your assets and what they're comprised of, tips for managing those digital assets during your lifetime, and then some legal considerations that you should be thinking about now. Taj will highlight, as Rick mentioned, exactly what certain types of digital assets are that pertain to cryptocurrency and blockchain, and Betsy will help on the administration side. So we're hoping to have a nice dialogue back and forth. So if you see one of the other panel members hop in, all of their input is very welcomed during the conversation. So as far as what are digital assets, this is a little hard to nail down because there's no generic or uniform definition of what a digital asset is. So depending on who you talk to and what context it is in, they may have a differing opinion of what a digital asset is. For my purposes and my feeling about when you're thinking about your digital assets and your estate plan or administration of your estate, I like to think of every possible type of digital asset. And that's really anything that is content that's stored in some form of electronic format. Those can be things like photos, videos, emails. I have a full list here, as you can see on your screen. Often digital assets are stored on tangible assets. So you get into your email and your photos and videos through an iPhone, a tablet, computer, smartphone. Those are tangibles, but those tangible items do have passwords associated with them, usernames, and then you can get onto apps or into an internet site for other digital assets. There's a lot of digital assets that exist today, and the technology is changing extremely rapidly. So the list changes all the time. I would highlight that email, and as we've experienced with the MIT alum who passed away, John Ross, email is one of arguably the most important types of digital assets that someone has. It offers sentimental value. There can be a stream of emails and information or documents that people save to their emails, but it also is very informational. When someone passes away, we can get a lot of understanding of what bank accounts they own with electronic statements, what payments are automatically being made every month. We no longer work in a very paper world. A lot of us opt into electronic statements only. So email can lead to that information. We store our documents, books, articles, blogs to the cloud, either through Google or other cloud format devices. We have music online. So much is turning into digital versus something you can feel like a CD or a record for music. So I like to think about anything that really is online that you need a username and password is often required to access that digital asset in its global sense. Each digital asset has value to it. And there's been studies about how many digital assets people have, and they estimate that those under the age of 75 have at least 200 accounts online. I'm sure those 75 and older, it's probably not too far off from there. About 17% of Americans, they estimate, have some sort of cryptocurrency. So these are not things that are just unique to a few subset of people. It's really a global part of someone's estate and their asset portfolio. People usually don't think about digital assets in the same way as their other assets, however. It often takes me a lot of questioning and pulling information out of clients to even understand and assess what their digital assets are, because they don't think about them when they don't have financial value. And so every asset you have to think about as having some sort of value or a liability to it. Some are obvious. There's financial value in things like cryptocurrency or non-fungible tokens. If you have a Venmo or PayPal account where money is being placed in it from someone as payments, or you have software licenses, Maybe you own a website and a domain name that's very popular and expensive. That can be valuable. But there's a lot of digital assets that are sentimental or emotional. That is where email, videos, pictures, blogs, social media accounts, that's where those come into play. There are millions and millions of Facebook users who are deceased, and you get alerted to their birthday or say hello to them, and they're not living anymore and the accounts haven't been shut off. So this can cause emotional distress to family members when they see that happen. So thinking about where you are online and where your assets are and planning for them. Some assets also have brand value or legacy. There's a lot of publications and royalties, copyrights, websites. You may have books that you've written. So that is a value as well. Often there's a financial value tied to it also, but it's also your legacy and thinking about how this material is going to be used after you pass away. There's also liabilities to digital assets. So some subscription services, you're paying a monthly fee, Netflix, Hulu, or a newspaper, periodicals. So also think about those assets that are a liability to your estate. And if they were coming out of an account, maybe a joint account with a spouse or a child, or to a credit card, if those are still being charged after you pass away, that's a liability and that should be contemplated as well. So since we have so many digital assets, they can be overwhelming to start to plan for. So when I like to start thinking about digital assets, I want to think about things that truly matter, because there are so many accounts. If I have 300 accounts, telling a client or advising someone to write all those down can be overwhelming. So I try to really have you, first of all, cut yourself out of all of your electronic devices and all of your accounts. You can remove cookies and saved passwords, remove all of that on your stored devices and your computers to essentially shut yourself out, and that you will experience what your loved ones would experience when you pass away. You have no access anymore. And then as you go over the next 30 to 60 days, as you log into each account, access each asset, think to yourself before you put in the username and password, does this have value to it? What would happen if a loved one, my spouse, my child, someone else was locked out of this account? Would they be upset? Is there a value lost? Or what would happen if they didn't know about this account? Would there be a liability attached to it, a payment attached to it? And if there's a value or a liability with the account or asset, it needs to be noted and put into an inventory. And over that 30 to 60 day period, you'll start to design this list of your assets. If you log into something and it's a free Boston Globe account that has no information attached, maybe just your email attached to it, lower on the priority list of writing it down. But certainly if there's subscription payment or it was something of value like pictures and email, videos of your grandkids, those are things that you're really going to want to make sure are listed.
Kristin,
So
can I
yeah,
stuff a question in there?
absolutely.
A lot of registration activities these days require sending a code to your cell phone. That doesn't work in this scenario you've spoken of. How does one mimic or duplicate that kind of a double security feedback, dual token analysis?
So for loved ones or for themselves?
Well, I guess it's for the loved ones. I obviously myself, I have my cell phone, so I can get it here. But what if I'm trying to give the loved one after the fact, they don't have my cell phone?
Yes. So this is where and Betsy will speak to this too, but I also want to touch on it because it's very important. And it doesn't just apply when you pass away, but there's limitations on using someone's password, username, the double authentication features that you put in place. Those should all be there. They're all for your protection. You want to make sure everything that you're accessing has a password. Maybe then also you set up facial recognition. You also set up so it sends a code to your phone. You can either keep these passwords for yourself in a list, or you can use online tools like 1Password or LastPass. to organize those passwords. 1Password, I know because I use it myself, will also do that dual authentication code. So you don't even have to have it necessarily sent to your phone. 1Password will keep track of all those, but those are for you and you alone. There's no law in place and there's no blessing to allow someone else to use that information. So when you get locked out or your loved ones are locked out of these accounts, and they are trying to use a password and then also need to use your phone for the double authentication and they can't get in your phone. I mean, in theory, they're not able to use that information anyway, because there's no legal parameters saying you can use someone else's password. So you have to get around it in other ways. So the password management is very important to you and you should have access to that information, but it won't necessarily help anyone else administering your estate. And they certainly can't be advised to use that information by an attorney to access those. So the inventory will help you not only keep record of what you have, and then you might, as you're going through and writing down all those passwords, consider using a password management system so that you don't get locked out and lost from your digital assets. But then within that, you should be discovering what needs to be done with each of those accounts. Since someone can't use your password, how do they access these assets when you pass away? So once you have that full list going, that's where we have to figure out what limitations do we have based on the service provider, the custodian, and what do? How do you advise your fiduciary? So on the inventory, I recommend writing down your information. If it's not on that inventory, then using a storage device like a 1Password. Again, that'll be private for you. For your fiduciaries, your loved one, your spouses, that's where you will want to note what they do with those assets in the event of your death or disability. And then you're going to have to piece through on very, very important accounts like email and photos and videos or cryptocurrency, anything that has a high financial value or a high sentimental value. What does that site require? So that you can do your due diligence ahead of time before you pass away. So the first thing that you have to be aware of are these terms of services that each custodian has. When you sign up for an online account, you get a box that pops up that's 85 pages that says, read this, and no one reads it. And then you click the button agreeing to it. Most of those terms of service are subject to change at any time. So even if you're agreeing to one version of it, when you sign up for it, it often changes later. And Betsy and I were having a conversation about this earlier because she does a lot of work on the administration side after someone passes away. And Betsy, I would love your 2 cents on this, since you had some good thoughts about how frustrating it is from your company's perspective of dealing with those custodians who are constantly changing their terms. I think it would add a lot of value.
Actually, Kristin, I'm delighted to talk about this. One of the things that's very clear is Facebook says we are giving you permission to use our system, and you cannot transfer that position and that permission. So what are you supposed to do? What you can do is assign a digital fiduciary, somebody in your will and in your trust who you are officially giving permission to act on your behalf when you are no longer able to do so. And in that way, what you are doing while you're alive, and even in your will and trust documents, you are assigning that responsibility to act on your behalf. Then the custodian, the Facebook, the Google, the Apple, must listen to the fiduciary, because that is the law, the legislation in the state of California where these companies are headquartered. Now, I will touch on this just a little bit more. When you decide that your 14-year-old nephew should be your digital fiduciary, or your 14-year-old grandson, and they don't have the responsibility, they may sort of know how to do it, that's a bad choice. So you should assign somebody who is responsible, understands what your wishes are, and will in fact follow what has to be done. I'll go into terms of service a little bit more, but Kristin, why don't you go ahead?
Thank you. So as Betsy touched on, there's lots of different companies that she deals with, and they will, constantly change who they will talk to and what information they will give. I've outlined a few popular items here. This presentation came about because of that concept of email and being blocked out of an MIT email, which was pretty upsetting for the family. I think the contents of the MIT email was actually deleted prior to John Ross's family being able to access it. Since then, it's my understanding that MIT has changed their protocol with email. So when they are alerted to someone passing away, either with an obituary or some proof of that person's death, of the deceased alum, they will keep that email open for a certain period of time. Now, if John Ross had done a digital asset inventory and thought about these things prior, and Elise, do you have something to add on that for the MIT account? Oh, okay, sorry.
Sorry, yes, we do keep them open for 90 days.
Okay, excellent. Thank you for confirming that. So if he had done his digital asset inventory, started to think about those really important accounts and said, wow, everything tracks through here, and reached out to MIT for their protocol of what happens to my email when I die, he could have been informed at that time what would have happened. He may have then advocated to have that procedure changed. Who knows? Sometimes, unfortunately, you have to experience it the hard way before things are altered, but it may have alleviated that issue. So for other companies, they are thinking about that same thing. LinkedIn, which probably most of you are phasing out, you just notify and they delete the account. A lot of companies like Google, Facebook, Apple, which is coming soon, will allow you to create an inactive account manager or a legacy contact that can access your accounts. So a lot of us use Gmail. It's a very easy way within your security settings to go in and assign who gets notified if you have not logged into your account for a certain period of time. And then it sends them an email and they will get access to that information. You can limit what they get access to. If you have PayPal or Venmo, a lot of those sites will, upon notice of death, liquidate, the account and make a check payable to the estate. So that has to be contemplated. Instagram, even though they're owned by Facebook, does not have a digital heir or legacy contact at this point. Hopefully that will be coming soon. Accounts that you may use a lot with family, like Skype or Zoom, those should be noted, and maybe they're closed down, but they don't tend to store information. So the videos that maybe you've captured from a Facebook session are stored maybe through Apple Cloud or through another device, or maybe you've emailed it to yourself. Those entities that are holding that item, you'll want to figure out how they handle that. So more companies are coming up with protocols, but you may have to do some due diligence to figure out exactly what site and what their protocol is, and then note it in that inventory of what you've done. And you do have to look at it regularly, since they do change their procedures, or sometimes these settings get wiped away on an update. So you can't just do it once and assume it's going to happen. So that's a way that you can figure out what you have, what's important to you, manage it yourself within each site the best you can. And then things that you just can't figure out how to manage appropriately, that's where your estate plan and the law comes into place. And I feel like I've talked way too much already, and I apologize, so I'm going to rush through this part, but everybody has my contact info. So if you want to discuss anything further, always reach out to me after this presentation. But we have a lot of other wonderful panel members that I want to make sure have time. So the two things I will just touch on is, again, I mentioned there's no allowance of use of passwords under the law right now. Every state differs as far as digital assets. Massachusetts is one of only 2 states that has not passed any sort of uniform digital asset law. So most states have that. So if you're outside of Massachusetts, it's likely that there's something in effect. If you're in Mass, we're still waiting. So push legislation to pass it to give fiduciaries access to those digital assets and they're able to present information to custodians and force them to provide that information over. Since you don't have that in Massachusetts, or even if you do have such law, uniform law in your state, it's always super important to make sure that digital assets are contemplated in your estate plan. You need to have an estate plan. Every person in this room should have one, whether you've done it yourself or you did it with an attorney 2 days ago or 20 years ago. You just want to make sure that whatever those documents contain, they have powers for digital assets for your fiduciaries. Power of attorney, your will, if you have a trust, that those powers are specifically listed. And then if you have digital assets that you want to go to a specific person, maybe you have cryptocurrency that you want to go to your son instead of your wife, or a website that you want to make sure goes to a friend of yours who's going to manage your legacy and manage that website, you will have to outline with that within the plan itself to distribute those documents in a very specific way. So don't assume your documents have digital asset powers in them. You need to pull them out and look at them, make sure they're specifically in there. Don't take it for granted. And then if you, as you're doing your inventory, have anything really important to ensure gets passed on, that's where we want to contemplate that within the will or trust itself as a specific distribution. A large part of this component is cryptocurrency. So I'm going to pass it over to Taj, because this is really burdensome in administration and can cause a lot of complications. And you're all here to learn about very cool things. So I'm going to pass it over to Taj to talk about the much more interesting topic of his digital asset world.
Thank you, Kristin. Taj, you're on.
Okay. Hello, everyone. I think I can see me. I'm going to share my screen. Hold on. It says this will stop the others, but yes, that's okay. Here we go. This should be. Can you guys? Is this? Hopefully, it's visible.
Working fine. Working
okay,
fine.
Great. Let me move this out of the way so you can see that. Great. Oh, sorry. Okay. Hi. So I'm Taj Dryja. I work at the MIT Digital Currency Initiative, and I've been sort of working on Bitcoin for actually quite a number of years now, since 2013. And we'll explain sort of inheritance of just general idea of Bitcoin and cryptocurrencies and how they work with inheritance. And it's definitely tricky. So the general idea of Bitcoin and then later cryptocurrencies, this first started in 2009. And what's important to know is this is not a company, it's not regulated. In the case of Bitcoin, nobody knows who started this system, some pseudo-anonymous person. And it presents some pretty unique challenges for inheritance. So one thing is just how to identify Bitcoins, like where do these things live? And there's sort of multiple places they can live. One is, wallets, electronic wallets on computer programs, so on a computer. Another is you can write these things on pieces of paper. There are also hardware wallets, and then there's also accounts on exchanges. So I'll talk about these a little bit more. So at its base level, Bitcoins and most of these systems are bearer assets. So really think gold coins rather than bank accounts, right? These are, they're not physical objects, but they're not tied to anyone's identity. So when you're transferring Bitcoins around, there's a network of computers that understands and keeps track of sort of who owns what, but it's not really who, it's just secured by private keys. And private keys are what, allow people to sort of possess and control Bitcoins. And these are, just digital, numbers. And in practice, they're, 32 bytes of sort of random numbers. And you can write them on paper, right? So you can, generally they're stored in some kind of computer database, some kind of software. You can also write them out on paper, and they look like these long strings of random numbers and letters. And I put that, 5J, 5P, whatever. There are also easier to read and write techniques where some people, some software uses it and says, okay, we're going to make 12 random words that are English words like this: forest, decorate, Paris. And that has the same information as a long string of random numbers, but it's easier for people to read and write, right? Because it looks like regular things. So if you see these kinds of things, hey, that might be Bitcoin or some other currency. There's also hardware wallets and exchanges. So hardware wallets are small physical objects that usually have some kind of like little LCD screen and a couple buttons. They're purpose built to store these private keys, and they often are secured by some kind of numerical passcode or short password as well. And then there's exchanges, right? So exchanges are the equivalent, they're where people buy, sell, and store Bitcoin. So in the case where people are using exchanges, they don't have quote unquote physical possession of the Bitcoins themselves, but they have a custodian. So this is probably much more like bank accounts and stock market funds and things like that, where the sort of traditional ways where lawyers call up and say, okay, this person's dead and we're handling their estate. And then there's a company to call in that cases. So there are many U.S. exchange. There's 3 or 4 major U.S. exchanges: Gemini, Coinbase, Kraken, and that's sort of going to be more standard for lawyers to deal with. However, even in the exchange case, it can present a challenge because there's a lot of offshore exchanges that are I don't know how to put it nicely, really sketchy. And it's sort of, you're not a bank, you don't have a bank account. There's these offshore exchanges that have very little oversight, and sometimes you don't even know what country or jurisdiction they're in. And they sort of are these fly-by-night exchanges, so that might be very difficult to get a hold of, and they might not care. So those are some of the challenges. And I would so for cryptographic inheritance, there are several techniques that I think are probably pretty good ideas. One that can be the simplest is print these things out on paper and give it to a lawyer and say, okay, well, these are my Bitcoins. I'm not giving you ownership of them, but I'm putting this in an envelope, and don't open this while I'm alive, kind of thing. And that's sort of I think it's useful because it's things that we are used to. There's nothing that new about that, right? There are also some techniques such as multi-signature that can be useful as well, where multi-signature is fairly well established. It's been around for 8-10 years in all of the software, where you can say, okay, instead of one private key, I'm going to secure this asset with multiple private keys. So I can say, okay, it requires 2 of 3 keys, or 3 of 3, or 5 of 7, or any combination M of N private keys. This allows you to do things where you're like, okay, I have my own private key here, but I keep a backup with a lawyer or with family or things like that. So that if I were, and you can also sort of prioritize so that, okay, my key can sign on its own, but if I were to lose this key, or if I, am no longer able to do this, then my lawyer and my children or my sibling can together control these assets. And that's fairly well supported. There are also more advanced things that I would say, purport to deal with these, like, time transactions and vaults, where you can say, okay, well, if I don't move my funds within 2 years, they default to moving to someone else or some other address. Or these like smart contracts that specifically deal with inheritance and say, okay, here's a trust fund that doesn't involve lawyers or law firms. It's just all on the blockchain. As someone who works on these things, I think it's really interesting. I think it's cool. I also wouldn't actually recommend this. I think it's still very experimental. And putting a lot of money or a lot of value onto these things, and I don't think it's ready yet in general. For people who are really into it, hey, you can try it. But I think for the vast majority of people, the safest option is definitely print things out, or give custody to give access to some kind of law firm or lawyers, and they deal with it. You can also do multi-sig with friends, family, things like that. That also works. I would also I'm going to go pretty quick because I know we have limited time, but my other general advice would be watch out for over securing assets. It may be selection bias in that I work on Bitcoin, and most of the people I know also work on these systems, and so we're generally very careful and paranoid about these things. But among the people I know, there's much more loss due to over secure, where I put this extremely complex password, or I put these extremely, I made a very secure system, and then, oh shoot, I can't access it. It's locked out forever. It's gone. Much more of that than due to theft or things getting stolen because of carelessness, or because, oh, I left it on my phone, which was unlocked, and someone stole it, or I left it on my email which someone got access to, or anything like that. That also happens, but at least in the people I know, and maybe this is MIT alum, so it's probably a similar cohort, where watch out for over securing assets. It's not hard to sort of make a lock so great that you can never access it yourself. And I've seen that's also a very real danger with these things. So that's the end of my slides. I will turn it over to our next speaker, and we can do questions after that too. So thanks.
Taj, thank you very much. Betsy, you're on.
I am on. So I am going to be talking about protecting your digital property, how you actually locate and secure and organize your digital assets after death or disability. I like to use pictures to give you this idea of where everything is in a digital world. As Kristin said, most people under 75 have more than 200. And if you begin to say, you've got to be kidding, 200 is a large number. Well, earlier Rick told me he had 7 pages of just user IDs and passwords, probably over 200. On this particular screen, you'll see airline miles, Southwest, American, and so forth. And you'll also see a red tile over here, and that represents LifeLock. This is an online identity theft protection service that is very popular. They monitor the transactions that are happening on your credit cards, and many people use it. They also use their competitor, which from TransUnion or Experian. However, all those contracts cease to protect the digital assets as of date of death. This isn't even in the fine print. It is right online. The other thing that's very interesting is some people have subscriptions like Life Alert, Netflix.
Betsy, you are not screen sharing.
I am not screen sharing. So let me figure out what went wrong. All right. I'm not sure how to do this. So,
I'll tell you when it comes up.
okay. Oh, gosh. Okay. Just a second.
Working fine.
Okay, great. So we will just go on to our next slide here. Can you see it now?
Yes, ma'am. Works fine. Thank you very much.
All right. I'm sorry about that. I'll just say quickly, the LifeLock tile means somebody is monitoring your credit cards. It ceases as of date of death. Also, there are subscriptions that people have like Life Alert or Netflix that will take money out of a bank account on a regular basis. Upon disability or death, you want to make sure that you have a plan in place to deal with all those different assets. And on the lower right-hand corner, you'll see Lyft. And Lyft, like Uber, didn't exist 8 years ago. So one way to find out where all your digital property is to look at your cell phone. Every tile means that company has information about you on their computers. What will happen to them after life? They will just sit there. They will sit there forever, unless somebody decides, the fiduciary, the executor of your account, what is going to happen to those particular accounts. The financial accounts and the insurance accounts are pretty much taken care of, but the shopping sites are not. Shopping sites could be Amazon or eBay or Craigslist, where you buy and sell things and people have accounts. If you're buying and selling things on Amazon, forget about selling. You're buying things on Amazon. They have your credit card. Who will be in charge of contacting Amazon and saying the records you have on file belong to a deceased person? The person that you assign to that responsibility, and that person can be somebody that you believe will be responsible and who will accept the responsibility, either of doing it themselves or asking someone else to do it. The often overlooked assets that people don't realize are digital assets are usernames and permissions that you have given to other people to use those names. If you look at your bank account, bill paying will continue if nobody notifies the bank. Social Security checks will continue to go into that account until the funeral home notifies Social Security. And then Social Security will stop the Medicare withdrawals and the Social Security payments. But when they do that, they will also tell the bank the records you have on file belong to a deceased person, and they will freeze that account. I hope you realize. So what I do recommend is that you have a bank account that only accepts your Social Security check. And then on a regular basis, 3 days after it appears, you then transfer it to your working account, so that if Social Security closes that one account, at least the rest of your financial world will not go away. The financial records are in fact electronic records that belong and represent your accounts. Those are digital assets according to the law. So the question is, what do you want to have happen to them? This is a checklist. My housing costs, my assistants. The assistants could be the cleaning lady or cleaning service. It could be the somebody who takes care of the garden. The shared financial records. If you have an account that is a trust account for a couple of different successors and you are one of them, what's going to happen to those shared records? I want you to start to think about that. Credit monitoring services will cease. So the fraudsters have a wonderful procedure. They read the obituaries, they go to social media, they use search to find out enough about the person to create a new persona. They then open up a Facebook account with a picture of the decedent. They now have picked up the Social Security number. They buy it for $20 on the dark web. They then go to banks and apply for credit cards. The credit reporting companies don't know that the person has passed, so they issue a credit card. As long as the charges are under $8,000, the banks will not demand any payment. This can go on for 90 days. So that's $24,000 associated with a deceased person's account, many different banks. What is my recommendation? Don't put a lot in the obituary and assign somebody to close social accounts. And on a regular basis, you might want to get rid of the search results. Put your name into Google, see how many times it appears. When in 2000, social media started getting popular, you would put your name in and say, oh, it appeared 29 times. Today, if you put it in, it'll appear close to 100 times. You probably want to take action today to get rid of that. Lots of digital assets will remain after a person passes away. They will be lost because you didn't tell somebody about them. They will be stolen by the fraudsters or well-meaning relatives. And sometimes bank account values decrease because nobody's paying attention to them. What is the risk? 1 out of every 8 estates experience identity or other theft and loss. These are reported to the FTC. The FBI used to collect this information. They don't anymore. The second thing that happens post-death is that a lot of assets are abandoned. AARP did a study and they found that over $60 billion in assets were abandoned each year. I'll share a story. Our company was asked to help identify all the assets of a decedent. It was a woman in her 80s. She lived in Scottsdale. The attorney said, see if you can find anything that belongs to this person. What had happened with this woman, she owned two condominiums, one she lived in and one she rented. About 6 months before she passed, she sold the rental. The title company sent her a check. She never cashed the check. By law, the title company had to turn over the money to the state of Arizona. That process is called escheating money. Money is escheated $60 billion a year, every year. By just identifying to the Secretary of State in the state of Arizona that there was an inheritor of the estate, the money was able to be taken out of the state and given to the 45-year-old son. Do you have to wait until somebody's dead? No, you can do that today. There's a website called missingmoney.com. And you just put in your name, you put in the state that you live in now, you put in the states that you lived in the past, and if any money has been turned over to the state, you will find it. You can request for it to come back. If it's $1.06, you don't care. If it's $250, if it's $142,000, you'll care. The digital asset record keeping is creating an inventory, locating those hidden assets with missingmoney.com. Very important thing. Checking that you have the right passwords is also a good idea. Our experience is that a list of passwords is rarely complete. It's sometimes not even correct. If it's a long string of numbers, if it's a strange set of letters and numbers, sometimes they're just not even correct. And the third thing is they're not current. So you can have peace of mind thinking that you have accounts and user IDs and passwords. However, in the 48 states that have legislation in place regarding access to accounts, they specifically state in Section 15, the fiduciary cannot impersonate the user. Okay, can the fiduciary identify themselves and say, I am the fiduciary of this account, of this estate. I have been given permission to get to this digital asset. Great. At that point, you don't need a password. Interesting. So there's a false sense of security. I have the accounts, I have the usernames, I have the passwords, I'm all set. Will the spouse, will the widow actually be able to have the presence of mind to deal with this? Probably not. I guess the most important thing is to realize there is a value to being organized, but now you want to think about the next step. What am I going to do about it? So you are all individuals. I hope you all have professional teams, meaning a trust and estate attorney, a wealth manager who works with a trust and estate attorney. You're working with a trust company that has attorneys on board. You want to discuss your digital assets with them and have a complete list so that your professional knows what assets are in your estate and also might look at those assets and say, these aren't balanced properly. There's too much real estate. There is too many private businesses. So it's not just a matter of thinking about what will happen to the digital assets post-death. It's important for having all the digital assets and all the wealth defined. One of the most important pieces of information that you can consider sharing is, how does somebody get into a cell phone? If you have an Apple, you're just going to assume everybody has a 6-digit PIN. Well, yes, if you have an Apple, but if you have a Samsung, it's only a 4-digit PIN. The other thing is, I like to take this opportunity to explain what multi-factor authentication is. It means that you know something and you have something. You know your passwords. You know the answers to the questions. Okay, lots of things to know, but what do you have? You're holding a cell phone. You're holding a key, holding a thing. You're putting your fingerprint on a reader. So multi-factor means I know something and I have something in my hand. Here are 8 reasons, if I haven't convinced you so far, why you should secure your digital assets. First, usernames and web domains generate income. And you will actually be surprised how much a username can be worth. $30,000. You might have bought it on a lark at the beginning through GoDaddy and never realized how much iloveyou.com, iloveyou@gmail.com is worth. Probably a lot. The photos, the videos, the emails have sentimental value. In private business partnerships, often they're not on tax returns. It's just in a document that is sitting either electronically on your computer or shoved in the drawer. And if nobody knows about that partnership, it is not unusual, and it happens all the time, that 3 people started a partnership. And the document said, if one of us dies, the other 2 will pay into the estate the value of the deceased partner's share. But if nobody knows about the partnership and the partners who are still alive say, you know what, nobody knows about this, we're just going to take the value, that 1/3, and share it between the 2 of us. Does it happen? Yes. Does it happen more times than you want to know about? Sure. I've talked about abandoned assets and bank accounts. They remain unclaimed. The good news is that there are laws in place in every state that require, after inactivity of 3 years and an attempt to contact the account holder, the insurance companies holding premium payouts and bank accounts, financial institutions that are holding bank accounts must turn the money over to the state. On a federal basis, if the federal government has issued a check and it hasn't been cashed, they are required to keep it. They are only required to keep it for 3 years, and then they have it for themselves. The fraudsters impersonate decedents and steal the assets. The example I gave before is called ghosting. I have a 2-page article on it. If any of you want to really drill down and understand how that works, just contact me afterwards and I'll send it to you. Also, fraudsters discover your intentionally hidden assets. They're really good at this. And assets are easily and illegally transferred to new owners. You have to guide your financial advisors and your attorneys as to what to do with your digital footprint so that after life, your legacy remains as a gift to the next generation. The inventory can be used to secure assets, but it's difficult. The banks don't want to freeze the accounts because banks use the deposits to earn money. They're not real excited about freezing an account. They make it difficult. Citibank, on paper, says, in order to notify us that an account is closed, you must have the fiduciary or an estate representative go into the office and speak to the bank manager. Well, this is nice. I live in New Mexico. Lots of people live in Arizona. There is not one Citibank branch office in either state. Interesting. This is a fight I've taken on. I love this fight. The other, it's unbelievable. Insurance, when the time comes, people will say, oh, I'll take care of the insurance. Well, the life insurance was with one. The auto insurance is with State Farm. The pre-need insurance is with Guardian Life. The long-term disability is with Liberty Life. Do you think what I'm sharing with you is unusual? No, it isn't. Insurance payouts often are handled outside of escrow, whether it's life insurance or other kinds of insurance policies. The issue of insurance coverage differs, whether it's property, auto, pre-need, long-term, and so forth. I'm going to suggest that you make a list of all the insurance policies you have and what should happen to them, and share that with somebody. Loan documents can be a problem. I'll share another story. A 45-year-old young man passed away. When he went to buy his first house, he wanted a loan. He couldn't qualify. So he asked his uncle to co-sign on the loan. Well, that was great. The uncle had great credit. The 40-year-old passed away. Payments weren't made to that company exactly on time. So who got dinged? Well, the deceased son's credit got dinged, and that didn't matter. But the uncle's account got dinged also. And it didn't matter how many times the uncle spoke to the banks and the credit card ranking companies and the FICO developers. They said, I'm sorry, your name was on that loan and it wasn't paid. It was delinquent for 2 months. Therefore, your credit score is going down. And we don't care what the situation was. Message: if you have ever co-signed on a loan, think about what that means and have a plan for dealing with it. The patents, trademarks are registered with the USPTO. Up until a couple of years ago, it was very difficult to look online and say, does Pat Green, as a name of a decedent, have any trademarks associated with their name, any patents associated with their name, any copyrights? Now you can do it online, uspto.gov. So it would be interesting if you know that somebody recently passed, you could just put in their name and see if they had any assets. These are digital assets. You don't think of it that way. You think cryptocurrency is the only digital asset. No, these are royalties.
Betsy, your energy and enthusiasm and the depths of the issues are awe-inspiring.
But I've gone over time. Right?
May I address some of the questions, because we do have an audience, and there has been a trend in maybe half of the questions, and I think many of us are troubled by this sense of nobody's allowed to share passwords and somebody else can't use your password. What I detect here is that there's possibly a difference between the legalities and the practicalities of shared passwords. For example, my wife has all my passwords, she has all, and I have all her passwords. We use them interchangeably. And the sense that she's not allowed to use them, or after I die, she's not allowed to use them, that's troubling. Can you give me what I'll call a practical rather than a legalistic answer to that conundrum?
Yes. The issue is the fiduciary, the named person, cannot impersonate another for their own personal gain. Impersonating is not okay. Was it your intent for them to sign on and read all your emails? You have to decide. As far as Facebook is concerned, Facebook makes it very clear. We gave the user, the person who set this up, permission to use our account. No one else can do it. You know what? This is like a speed limit on a highway. It says 55, but if you go 75 and nobody catches you, you get away with it. However, if you go 75 and you have an accident, and the police say you were going 75, that adds to the nightmare that one is already in. You cannot, so in different situations, this is my recommendation. You identify in your trust documents, which is a living trust, and in your wills, a digital fiduciary, somebody who you are giving permission to act on your behalf, whether you're disabled or whether you've passed away. But you cannot just sign on as another person and start reading their emails if you have not been given permission to do so, whether the person is alive or dead. So you should have a document that deals with these issues. And that's where you call in Kristin to help you write that document. And it's not a big deal. But this idea, so with some of the products, 1Password, whose headquarters are in Toronto, Canada, they have said you can open a family account so that you can, upon setting up the password manager, authorize another person to look at that information for the purpose of getting into your account. Now, getting into the account is the other issue. When you signed on with Facebook, you clearly said you were told and agreed to the fact that you would be the only one getting into that account. When does it matter? It matters when assets are stolen or when privacy has been invaded. That's the real issue. Impersonating is against the law. Acting on behalf of, because you have been given permission, is not against the law.
Okay. I think that's I understand. I think you also stated a critical issue there is that you may not impersonate someone and if you're acting, solely in your own interest, but if you're acting in for the interests of that person who has passed away, then maybe there is, again, a practical sense that you are acting in their interest rather than your own interest. But I do see that there is a perspective there. But as I say, of the 25 questions, about half of them are wrestling with the, to be honest, confusion that this represents. Kristin, can you provide a little perspective on this issue? Because as I say, many of us are just sort of, what are they talking about?
Yeah, it's maddening. And as a lawyer, I can't authorize anyone to use passwords, and I'm under a lot of limitations, and I have to be very careful when I'm guiding fiduciaries because there's fiduciary liability. You can be charged with something, you can have a fine involved, you could have face jail time for things. As a human being, and Rick, where everybody, you and everyone in this room is coming from, which is like, this is crazy. I have my husband's password. Why wouldn't I just log into his Netflix account and use it? So you do have to kind of decide on for yourself, what is the practical way you're going to deal with something. But once you have an attorney involved, they're never going to advise you to do that. And it doesn't make sense. And the laws sometimes do not make sense. So to try to make sense of them in your brain, you're just going to go crazy. But it's limitations under the law with privacy. And lobbyists, they tried to authorize this in the past, and password use, people just claim privacy, but the person who has email and is emailing someone outside of their marital relationship, they don't want that to be found out when they passed away. So they use these anecdotal stories, and it all comes down to privacy. So you're going to have to use your judgment, but you're certainly never going to get an answer from someone that says you can use the password, even though that's what feels logical. It's just not. And as Betsy pointed out, the law accounts for other ways to access it. You will get access to that account through providing other information. You don't have to use the password to get into that account.
Understand, as I say, there's a difference between the pragmatic and the real and the theoretical, and we all walk that fine line at all times. And I think it's as long as we approach it with good intent and integrity and honesty, we should be all right. Although we may step over some formal steps there.
Yeah, there's a bigger problem. If people just impersonate somebody else, the custodian can say, you told me the date of death was March 1st, but somebody got onto the account on March 21st. We are not giving you access to that account unless you resolve this issue. And if that account happened to you, your Bank of America account with $900,000 in it, and Bank of America has locked you out because the name of the account was of the decedent and someone else tried to sign on past date of death, now you have created a problem that is going to be very expensive to unravel.
Is that a problem if it's a joint account?
No.
Okay. So again, there are practical dimensions as to how these things are structured. Okay, as I say, our time.
We're out of time.
Our time is passing. However, I would like to have each of you an opportunity to at least have a closing comment. I did want to point out to our audience, number one, this program is recorded. It will be available on the Cardinal and Gray website probably in 2 weeks. For your viewing pleasure, and all handouts, which are the slides that people have used, the PowerPoint slides, will be distributed as a PDF to all registrants within the next few days. So all the material will be there, and obviously the contact information for our presenters will be there. Kristin, did you want to have a couple of final remarks?
No, just thank you, everybody. Remember to look at your documents, talk to your attorney, or make sure that you're well prepared ahead of time so you don't leave a mess for loved ones. If you do leave the mess, make sure they have Betsy's information so she can help walk them through it.
Okay. Taj, any thoughts? I know you come from a completely different world, but a world which is the future for many of us, and we're intrigued.
Yeah, thanks. And thanks for this opportunity. And definitely tell people, because it's even harder. Maybe people don't know if you have Bitcoins. So that's another, just tell people about it, talk about these things, and definitely make a plan, because the default in a lot of cases is much more difficult to recover than other types of assets. So planning is definitely needed here.
Thank you. Betsy?
Thanks.
My last word is that you should think about what will happen to your digital assets. You might want to write a letter saying to an individual, if you're reading this letter, I have passed away, I have assigned Legacy Concierge, the locket service, to handle this estate. Contact them. They will be able to organize the digital assets. Most of our clients have done that. They've organized their assets, and then they write a letter making reference to our company.
What we have in our audience is they're MIT graduates, sort of by definition, so they have a lot of self-confidence. They may or may not have lawyers, but they also probably have a lot of common sense. So as always, ladies and gentlemen, common sense is controlling. And please do your best. But as you can see, the issues that we have been addressing today are challenging. They're new, as you've seen from the fact that we had 20 some questions and now up to 34, and we've only been able to handle a handful of them because there are concerns and depth of issues, but it's important. And we really thank you very much for your time and attention this afternoon. So good evening, good afternoon, and think clearly on these matters. Bye now.
Thanks for joining us. And for more information on how to connect with the MIT Alumni Association, please visit our website.